turn now to Richard Alexander Law. We talked a little bit about, when Richard comes on, about changes in legislation, maybe DUI, that kind of thing. We had a conversation, though, about students. He's a teacher, and I wanted to know what students are thinking out there, or why they get into it. And then that sparked this interest in television and radio, because a lot of us think that we've seen Law and Order episodes, and we're prepared in the event that we get into a situation. That plays out in real life, I'm sure, all the time, where someone says, "Oh, no, I know the law here."
Actually, you prompted me, because I reminded me of something. You mentioned 12 Angry Men.
Right.
Henry Fonda, on obviously the star of that show. And that's a very unique movie. It's one of my favorites, because the entire movie takes place in the jury deliberation room. And, Henry Fonda's the lone holdout. It's a 12-person jury, because the charge is a first-degree murder. And it's an amazing way, an hour and a half, of just to see how he talks. And at the end of the movie, he ends up doing a better job than the defense attorney.
I don't know how many of you folks out there have had jury duty, but it generally is something nobody wants. So
Wow.
the idea that we're going to learn about what goes on and understand our process, the judicial process, most of us don't really want to do that. When we get that letter, or we get told that we have to show up, we're trying to duck it or get out of there. It's a chance to really learn how this thing works.
Yeah, it really is. It's unfortunate that because I'm an attorney, I'll never be picked to be on a jury. I will get excused immediately.
Right.
And I can say for myself that when I pick a jury, I don't want a lawyer on there either, because what tends to happen is the other members of the jury defer a great deal of power and influence to that attorney. And that's not necessarily true. You may not have a trial lawyer.
I see what you're saying. So the composition of the jury, you got to consider who's going to be the leading voice in that room when you
have to pick a four-person, correct, as soon as the jury deliberation starts.
And if that person had a background in the law, or felt like they had a law, they would be giving direction. And that's not really the role.
Wouldn't you? Yeah.
Right.
I mean, wouldn't you say, well, wait a minute. Hey, you're a lawyer, right? I remember that. Yeah. Do you want to be the foreperson? Sure. And then they'll defer way too much power and influence to that person.
And that's the whole concept behind it. We want a jury of peers. We want everyone's influence, right?
Right. That's exactly what it is. You're supposed to. Some judges will not let jurors take notes. Some judges will. It depends on the judge. But because they don't want you relying on what that person wrote in order to make a decision. Maybe the person wrote down something incorrectly. Maybe the person has a built-in bias that you don't know about. And they don't want you relying on someone else's notes.
Interesting.
So judges are very peculiar about note-taking during the trial. So,
Richard, as an attorney during jury selection, you're trying to figure out whether they're empathetic to your client. I mean, what is actually going on there when you're trying to make those decisions about what jury members you want?
Well, it's called voir dire, okay, and it means to speak the truth. That's really what it means. And what you're trying to do is you're trying to find 6 individuals. For the most part, you're not going to get a 12-person jury unless it's a capital case. But you're trying to find 6 individuals that will be fair and impartial. And that's really what, at the end of the day, you're just trying to find 6 people that will hear both sides fairly, equally, and then weigh the evidence, depending if it's a civil case or a criminal case, and then come to a decision. And that's really what it's all about. But voir dire can be a fairly complicated process.
I could imagine it's not necessarily balanced. You don't want elderly and young or male and female. It's about their views. So you're trying to ask questions to find out what their views are, their opinions?
Yeah, and again, this is where the judge comes in, because some judges have a questionnaire and they have it fill it out prior to them coming in. Or some judges will ask some preliminary questions and then let the lawyers take over. Or some judges will let the lawyers do all the work. So it really depends on the judge, and this is where they can have considerable influence on that process, the jury selection process, because what you're trying to find out is who's going to cooperate with other people, who's open-minded, who's had, let's say, maybe a member of their family has been a victim of a crime, has been a victim of a car accident, because they're going to carry that into the deliberation room, and they're going to carry a built-in bias whether you know it or not. It's going to happen. Whose members of the family are law enforcement officers, first responders as family members.
And as a way of researching that information, how would you go about finding out that information?
Well, you can't, because you don't know who's going to come into the room.
I see.
So if you don't ask it during voir dire, it's which way.
So that is your only opportunity to depose them at that point.
That is the only opportunity you can actually speak to these people as private citizens.
Okay.
And that's why it's so critical to be prepared with questions. And, this is the time you get the chance, if you want to have a conversation with them, I'm going to put the words informal in quotes because you really got to talk a little bit about why you're here. But the questions better be revolve around the impartiality, being unbiased. How do you feel about, you really, because if you have if you know it's an alcohol-related case, you better ask questions about how do you feel about alcohol.
Right.
Because if they say, I think everybody that drinks alcohol is guilty, you probably don't want that person on the jury if you're a defense
I think
attorney.
I just fell into the Law and Order trap that we discussed a little earlier because I swore that attorneys had private investigators finding out what the jury members' inclinations were prior to the jury selection. Why would that's just I just thought that, I thought, well, I know that from TV.
Look, here's the thing. Is it possible? I guess anything's possible, but I don't know who's coming into the
jury pool.
The jury pool, right? Because let's say they'll ask for 24 people. The judge will call down 24 people. Of those 24, you pick 6. 7, the alternate.
Right.
Whoever's not picked goes back into the jury pool. For other attorneys, other judges. So I have no idea who's coming through those doors.
That's another way to ensure fairness. It makes sense now that I think about it.
Is there a way to find out? I guess you can look through all the summons that were issued by the clerk and find out who's coming in.
Boy, but that time is not great because they just walked in the door.
Correct.
So that's not going to give you much opportunity.
Right. So, but look, I'm just saying there's a lot of people with a lot of money, and could they make that happen? I'm pretty sure they can.
I suppose it's possible. Now, tell us about DUI legislation. That's another thing where people out there think they know, here's what you do. If you've had one drink, fine, do everything. If you've had none, they have a plan. But it turns out that's not always the way it works in real life.
Well, DUI legislation in the state of Florida has been fairly quiet as of recently. We've had changes in the laws recently as far as .15, that's an aggravator.
The limits.
Right, it's an aggravator. You get doubled fine, and you have to get the ignition interlock device, mandatory. And I recently wrote a blog, and I talked about this some time ago on the show, that Utah went down to a .05. And why is that important is because Utah was also the first state to go to a .08. And now .08 is the standard.
Okay.
So I don't know if we're headed that way. I will say MAD, Mothers Against Drunk Drivers, is an extremely powerful lobby in the state of Florida.
Has Utah seen a spike in cases as a result of the change?
What I have seen more of is more marijuana-related cases. No kidding.
I'm curious to know how that's handled now with cannabis being, recreational in some areas of the country and not in others, and medicinal in some. It's going to be on law. First of all, law enforcement must have a real serious task in determining which one of these devices is. I see kids with vaping you can't tell what the product is or what they're using. So I wonder, law enforcement's a real challenge ahead of it with this vaping.
Look, I can say this, that marijuana has a very distinctive smell. And the smell has been held to be probable cause.
PC for an officer.
Correct. So if an officer smells that, an officer should be trained, obviously.
Right.
But if they smell that, then, they can go forward with a criminal investigation, which would be a DUI case. But, it's a case-by-case basis. There's a tremendous amount of pressure on law enforcement to do DUI cases, to make arrests and investigations. Again, MAD is an extremely powerful lobby. The state attorney's office is very aggressive when it comes to prosecuting DUI cases, to the point they won't dump them at all. They'll amend them to reckless drivings, but they will not drop DUI cases.
But with the sophistication of the devices for vaporizing, and then the phone and the texting thing that we're talking about with some of the technology, voice to text, and there's kind of a fine line to decide what the driver is actually doing at the time and whether the police officer can say with 100% certainty, I saw him do X, Y, and Z with his phone, or he was doing this or that inside the vehicle.
Well, that's what I was talking about the last time I was here, that now that texting and driving is a primary offense, let's just say, for instance, law enforcement pulls you over because he believes, he witnessed a traffic violation, in this case, texting and driving.
Right.
So he pulls you over, and, we talked about this, that you can't get into the phone because of the U.S. Supreme Court ruling on needing a warrant.
So you can't just grab your phone and look at it.
Correct. So what happens? Well, while he pulls you over for a primary offense of texting and driving, he picks up probable cause for something else. And
so
now
opens the door to another opportunity.
Exactly. It opens the Pandora's box, if you will. And now you have a full-blown investigation for something else.
We had talked a little bit today about some different items. I wanted to go back to Richard a little bit because I was kind of fascinated by the students and the teaching and some of the ways that we in the public think we know already what the laws are. We're confident because we've seen a television program or a movie somewhere that reinforced our view. What have you seen out there that you've noticed that people are way off base? They think that they can do this, and there's no legal basis for that.
Well, you actually made me think of something called, have you ever heard of the sovereign citizen argument?
I think I'm familiar with the phrase, but I don't know exactly what it is.
Well, they're dangerous, and I'll tell you why. They come to court, and they're armed to the teeth with, research that they've done on any particular case. And they believe that the government, the state, local municipality, judges, law enforcement, has no power and jurisdiction over them because they believe themselves to be sovereign. That means free and independent of any government control whatsoever.
And what establishes this sovereignty?
Well, they see themselves as sovereign citizens. And they say, well, not even the Constitution applies to
They don't
you.
recognize it.
Correct. And that's their first argument in front of the court. I love when they do something like, well, I don't recognize this judge's jurisdiction over me. And that's when a lot of the lawyers go, this is going to be good. This is going to be really good.
Well, how does the judge typically respond?
Well, he doesn't even consider it. He just says, we're going to set this off for a pretrial. I'm going to appoint the public defender to represent you. I mean, judges are way beyond that. They just know not to get into it. It's a lose-lose game for the judges because they're just going to get into a
back and forth.
Heated discourse, with the person accused. So they know better than to get into that. But I think a lot of it has to do with they think they know the law, and they come in with what's called the sovereign citizen argument, which is always fails.
You've seen this presented.
Numerous times, absolutely.
And this person had done research at some library or somewhere and felt like this just applies to me, or there's no formal declaration issue.
Correct. That's exactly right. They feel that they're going way back. I mean, talking 18th century.
Is there such a loophole that says if I choose to accede from the process?
Of course not. No, the states can't do it. I don't know why an individual thing. But the bottom line is they believe that it never applied to them in the first place.
Okay.
That the laws don't apply to them as enacted.
There's a lot of folks out there who just feel that the federal government, they have issues with the federal government. They're for the state versus federal kind of an argument. I suppose you could make that argument, but there's no legal basis.
Well, there's no legal basis. That's the problem with it. So, I think the ultimate irony is I'm going to use case law to show that the sovereign citizen argument applies to me. Okay, you do that. And who hands down case law?
Right. I mean,
judges.
So one way or another, you end up back where you started.
You end up back where you started, but they don't see it that way. I remember Wesley Snipes. Remember he was convicted for tax fraud?
Yeah.
He said he attended a seminar in which the speaker convinced him he doesn't have to pay taxes because it doesn't apply to him and Congress has no power over taxes. And since he's a sovereign citizen, he doesn't have to pay taxes. And lo and behold, he gets convicted and sent up to federal prison.
Yeah, I imagine that argument didn't last very long. I don't think they deliberated that long.
Yeah.
See, on the tax thing, it just looks like you're stealing, basically. It looks like you just don't want to pay your taxes. If you took a philosophical stand against some issue that put you in a light where you were actually doing something, or it wasn't just you not spending your own money, it might have, there might be a way to at least argue a little bit.
Right, like I don't want my money going to the gestation period of a housefly. Right, yeah.
Something along those lines. But just to say, I'm exempt. That's
exactly right. Because the speaker at a seminar told me I was.
So, what is it typically that students? I'm sure nowadays I get this all the time. That I'm stunned at some of the positions they'll take. But have you had this come up in class where they'll say, I really feel that this is wrong, or we need to change this because I've had an experience that runs counter to this. The law's been in place for years and years and years, but they feel like, hey, time for a change?
See, now you don't know this, but the timing of that question is really scary because the second question I get asked most as an instructor, as a teacher, is about the school shootings.
Is that right?
Yeah, and we just had one. We had two recently that happened literally within the past 48 hours.
What specifically?
Well, they want to know my interpretation of what I think should be done. And they said, do I think it's fair? Do I think it's proper what's going on? And what I do to them, I said, listen, let me give you a little bit of history lesson. When I was a kid, and I grew up in the 60s, 70s, and I said when I was a kid, the big thing was not school shootings. You know what the big thing was when I was a kid?
You're talking about domestic terror?
Nuclear war.
Oh, yeah.
Remember duck and
The
cover?
Cold War, yeah,
right?
under your
Remember
desk
that?
or whatever.
If you see a mushroom cloud outside your window, if you see a mushroom cloud outside your window, you're dead.
Right.
But that was the big thing: how to calm and keep kids, quiet. Hey, let's go through the drill. Get under your desk. Put your heads over your hand.
It is kind of unbelievable to think there was in facing annihilation, we had a drill. They would go through 20 minutes of moving the classroom kids around and setting them. It's a nuclear bomb.
But it was a way to keep the kids calm and not be afraid to go home and come to class the next day.
So we're taking steps.
So it worked. But that was the big scare back in the 60s and the 70s, nuclear war. It's not that anymore. Now it's school shootings. So what is the solution? I think the solution is training and knowledge. And, my school, both my colleges have active shooter drills for the instructors.
Yeah, you need to have a plan. That's for sure.
Exactly. What to do when there's an active shooter on campus. Because that's the new norm.
We had Thomas King from Florida Firearms Academy in here a while back.
I know of him. He's a professional.
And we had a story where these folks that were survivors of the Country Music Festival in Las Vegas, where they had an active shooter situation, they formed a support group online. They get together every once in a while. They pick an event. They picked the Garlic Festival in California, and we're at a second shooting. The guy pulls out. Can you imagine that you've been at 2 separate public events where a mass shooting occurred in less than 3 years?
The odds. Yeah. It's like surviving 2 plane crashes. Right.
So it's coming to your door, so you better have a plan. I mean, you don't want to be an alarmist about this thing, but how could you be unprepared at this point? You'd feel like it was your fault almost. It's out there.
I'm a big believer in having, actively either prior, retired law enforcement, retired security, top security at the school campuses, the elementary schools, the middle schools, the high schools. Have people that want to be trained. It's a 100-hour course, by the way, I believe. And have them on campus. Have the deputy's car outside. Be
a presence,
a deterrent. To saying, you know what, not that school. Let me go on. Why do you have locks on your door? To say, well, I'm not. The door's locked. Let me try the next door. I just think the training, knowledge, and experience is invaluable as to prevent.
It's always going to be the key: education and knowledge, just like we talk about here on the show all the time.